Hi, and welcome back to Mr. Raymond's Civics EOC Academy, where today we will continue to look at the judicial branch. We are mostly going to be looking at landmark Supreme Court cases, and these are famous court cases that have changed the way that the United States operates, and will show you the power of the judicial branch and the U.S. Supreme Court. Now, last time we looked at how the judicial branch is set up, what the U.S. Constitution says about this branch, its main power of judicial review, and what courts handle different types of cases. So if you haven't watched that, go to our channel and check it out. And our benchmark explains that the Supreme Court cases that you're going to need to know for your state exam are Marbury v. Madison, Plessy v. Ferguson, Brown versus the Board of Education, Gideon versus Wainwright, Miranda versus Arizona, in re Gault, which is in reference to Gault, Tinker versus Des Moines, Hazelwood versus Kuhlmeier, the U.S. versus Nixon, and Bush versus Gore. And just a reminder, teachers, that this PowerPoint with lesson plans, activities, worksheets, and more are available at Teachers Pay Teachers and Edmodo Spotlight, so just search for Mr. Raymond's Civics EOC Academy. Now, the first landmark Supreme Court case you need to know is Marbury versus Madison. We looked at this case in our last video because this case produced the main power of the Supreme Court and the federal judicial branch, known as judicial review. Judicial review is the power to declare laws unconstitutional. If you know nothing else about Marbury versus Madison other than judicial review, you'll probably still get the question correct on your exam. Marbury was a judge appointed by John Adams in 1801 after he had already lost the election to the incoming president, Thomas Jefferson. Jefferson's Secretary of State, James Madison, who you may know as the father of the Constitution and a future president, refused to give the appointment letter to Marbury. This was a fight between Federalist John Adams and Anti-Federalist and now Democratic Republican Thomas Jefferson. At the time, it was still a little unclear about what the job of the Supreme Court was. Now, Chief Justice John Marshall, who happened to be Thomas Jefferson's cousin, was able to clarify what the job of the court was in the ruling of this case. Justice Marshall laid out the job of the judicial branch when he declared that the U.S. Constitution was the supreme law of the land, and that it was the judicial branch's job to interpret laws as they pertain to the U.S. Constitution. In other words, should a law be a law according to the Constitution? He claimed that a law involved in the case that gave Marbury his job was not constitutional, and therefore it should not be a law. He claimed that if a law goes against the Constitution, it is the judicial branches to strike down that law, making it null and void. And again, this is called judicial review. With the establishment of judicial review, the three branches of the government were truly much closer to being equal. Remember our checks and balances, where the three branches were supposed to share power and keep each other in line. Judicial review is the main check that the judicial branch has on the other two branches, their ability to stop them from doing something wrong. Therefore, the big thing you need to know about Marbury versus Madison is that this case established the power of judicial review. This is almost guaranteed to be a question on your state exam. Next, we're going to be looking at 14th Amendment cases. Now, hopefully you remember from our previous videos the power of the 14th Amendment. You might remember that it defined citizenship following the Civil War. It also stated for the first time that state laws must be constitutional. In other words, the states could not violate any of your rights. Now, the 14th Amendment also states that no state shall deny any person, quote, equal protection under the law, unquote. And it's these essential words that provide the basis for appeal. In the first two cases we'll look at, Plessy versus Ferguson and Brown versus the Board of Education of Topeka, Kansas. This first case took place in 1890 at a time of great racial tension, especially in the South, just 30 years after the Civil War and the abolition of slavery. Homer Plessy was a man living in Louisiana who was 1/8 African American. Now, Plessy was an activist, which means he was someone who wanted to change things in America. He's kind of like the Rosa Parks of the 1890s. He had gotten on a train in Louisiana with the intention of getting arrested to fight segregation. Remember, segregation was the legal policy of trying to keep blacks and whites separate. Plessy bought a first-class train ticket and informed the conductor that he was 1/8 African American. He was a guy who could kind of pass for being white. When the conductor informed him that by law he would have to get into the all-black train car, he refused and was arrested. When Plessy was found guilty, he sued the judge, Ferguson, claiming that his 14th Amendment rights to equal protection under the law had been violated. Plessy's case made its way up to the U.S. Supreme Court, where the court ruled that public facilities could be segregated as long as they were equal. For this reason, the case is often referred to as the separate but equal case. The precedent, and again, all of these cases establish precedents, which are rules that will guide future cases. The precedent allowed segregationist laws to spread throughout the South. They're often referred to as Jim Crow laws that provided different accommodations between blacks and whites for everything from water fountains to restaurants. Signs went up all over the South as a result of this case. 60 years later, the calls for the extension of civil rights for African Americans took hold in America. We've discussed Brown versus the Board of Education in several videos before this. The segregationist laws that existed in many parts of America were being challenged, and this case combines several cases of African Americans suing over segregationist school laws. Linda Brown, a 7-year-old girl from Topeka, Kansas, who was forced to go to an all-black school despite the fact that she lived right near an all-white school, was the name chosen to represent these different lawsuits because hers was a case that wasn't in the South but was in the Midwest, and the court wanted to send a message that this wasn't just a Southern problem. The Supreme Court voted in a unanimous decision that segregating schools based on race was wrong and a violation of the 14th Amendment's promise to provide equal protection under the law. In the opinion, and an opinion is what the Supreme Court writes to explain their decision, Chief Justice Earl Warren wrote that the precedent of separate but equal established by Plessy versus Ferguson had no place in public education. That simply by separating based on race, these laws created an unequal situation. Therefore, Brown versus the Board of Education overturned Plessy versus Ferguson and opened the door to challenge segregation throughout the United States. Another case that appealed under the 14th Amendment's Due Process Clause was the case of in re Gault, or in reference to Gault. The unusual name for this case is because this was a juvenile case involving a minor or someone under the age of 18. Gerald Gault was a 15-year-old accused of making an obscene phone call to his neighbor. Now, rules for juveniles accused of crimes can be different from those of adults. Gault's parents were not told that their son had been arrested and were not allowed to attend the hearings in which a judge sentenced the youth to 6 years in a detention center, as this was not his first offense. 6 years for making a prank phone call. Now, during these hearings, Gault was never given a lawyer or was never allowed to present a defense. The Supreme Court ruled that Gault's guarantee of due process in the 14th Amendment, again, due process, the rights and rules that the government must follow and give for those who are accused of a crime, these rights had been violated. This ruling established the precedent that even juveniles must have protection from self-incrimination as guaranteed by the Fifth Amendment, as well as the right to a lawyer and to confront one's accuser with witnesses for your own defense as guaranteed by the Sixth Amendment to everyone, not just adults. Following in re Gault, juveniles could not be denied the same due process rights that adults are guaranteed. Next, we're going to look at First Amendment or free speech cases, both of which involve the rights of students, with Tinker versus the Des Moines, Iowa School District and Hazelwood School District versus Kuhlmeier. Tinker versus Des Moines was the case of 3 students who were wearing black armbands to school to protest the Vietnam War. The students were suspended by the school and sued, claiming their First Amendment rights to free speech had been violated. The court ruled 7-2 in favor of the students. In the opinion delivered by Justice Abe Fortas, the court claimed that the protest did not disrupt the learning environment and that, quote, the students did not shed their First Amendment rights at the schoolhouse gates. The court also ruled that free speech is more than just words, and it can include clothing or art or any way that people choose to express themselves. This precedent continues to be debated for students who believe that their free speech rights are being violated, as we have seen more schools impose uniforms and dress codes, but courts have ruled in favor of school districts in cases since Tinker v. Des Moines. And one of those cases is Hazelwood School District versus Kuhlmeier. Now, Hazelwood versus Kuhlmeier is the case of a student newspaper which was going to include 2 articles that the school found inappropriate. After the articles had been removed from the paper, the students sued, claiming that their First Amendment rights to free speech and freedom of the press had been violated. After the trial court found in favor of the school, the students took their case to the Federal Court of Appeals, which overturned the ruling, finding in favor of the students. The school appealed to the U.S. Supreme Court, which ruled in their favor. The Supreme Court ruled that because the newspaper was sponsored by the school, the principal could take out articles that would be damaging to the reputation of the students and the school. Now, Hazelwood versus Kuhlmeier further established the precedent that students' rights at school were not unrestricted in the ways that adults are in the real world. With this case, the court seemed to want to give the schools back some of the powers to limit juvenile rights in favor of maintaining an environment that's focused on learning. The next area of cases we're going to look at are rights of the accused, which again, hopefully you by now know are due process rights. And these includes amendments 4 through 8 of the Bill of Rights. The first case is that of Clarence Gideon, who had been convicted of breaking and entering and stealing money and property from a bar in Florida. Gideon was unable to afford a lawyer, and the right to a free attorney was only guaranteed by federal courts at this time, not state courts like Florida. Gideon wrote to the Supreme Court from prison and explained that he had requested an attorney from the state but had been turned down. The Supreme Court took on Gideon's case in a move to resolve this issue. The Supreme Court ruled that everyone was entitled to a lawyer and that a state must provide one if a defendant can't afford one. Now, most of you have probably heard of the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided by the state. Thanks, Gideon. Yes, the Miranda rights are named after Ernesto Miranda. Now, Miranda was found guilty of a serious crime, but his lawyer was able to argue that Miranda, a man with the intelligence of a child, did not know he had the right to a lawyer or to remain silent as provided by the 6th and 5th Amendments. Now, Miranda was accused of a very serious crime, and very few Supreme Court cases involve serious crimes, so the court was really looking to change the way the police operate. Some people are opposed to giving suspected criminals additional rights, but the court was looking to establish rules for police interrogation. As a result of this case, police officers are required to notify people who have been placed under arrest that they have the right to remain silent and the right to a lawyer. And this one case has changed the way that police have to operate in our country. Now, 2 of our last cases involve the Supreme Court ruling on the executive branch of the federal government. And these are the U.S. government versus President Nixon and George Bush versus Al Gore. The case of the U.S. government versus President Nixon was a result of what was known as the Watergate scandal, which took place during the early 70s. The Watergate scandal was when burglars were caught breaking and entering into the Democratic election headquarters at the Watergate Hotel in Washington, D.C. Investigators, helped by reporters from the Washington Post, were able to trace the break-in back to employees linked to President Nixon. Now, during the investigation, it was revealed that President Nixon had tape recorders going in the Oval Office of the White House. When the investigation asked Nixon to turn over the tapes, he refused, claiming executive privilege. Now, this case, heard by the Supreme Court, was a big question of the power of the president and the rule of law, or whether the law applied to even the president. In the end, the court ruled against President Nixon and forced him to turn over the tapes. The rule of law was greatly strengthened with its rallying cry that nobody, not even the president, is above the law. Next, and that concludes our look at the Supreme Court and the landmark cases. Up next is the rule of law and different types of laws, but before we go there, let's review. All right, as this video is getting kind of long, I'm going to cruise through these multiple choice state exam exam practice questions. If you want to spend more time with these, just hit pause for each one. Okay, what is the power to say whether a law or government action goes against the Constitution? Remember, the power is called judicial review, the power to declare a law unconstitutional. Which power was given when Chief Justice John Marshall declared actions by the executive branch unconstitutional? You know that one. It's judicial review. Anytime you see John Marshall, think judicial review. Okay, there he is again. Justice Marshall established judicial review, and he said that the Constitution was, quote, the supreme law of the land. What is filed when the Supreme Court wants to review a decision of a lower court? It is this weird sounding word. It is a petition for a writ of cert. What is the most important part of judicial review as it pertains to the judicial branch? What does it give this branch? Okay, the most important part is that it gives them equal power as the other two branches. So here's an example. Congress proposes an amendment. The Supreme Court rules that it's unconstitutional. What does this event illustrate? Checks and balances. All right, judicial review is the big check for the judicial branch. What case would most likely be heard by the U.S. Supreme Court? Would it be a murder conviction? Jury can't decide the outcome. Most cases are a case in which rights are involved, all right? It's usually about rights when it gets to the Supreme Court. Which case extended the 14th Amendment's guarantee to equal protection? Was it Plessy, Brown versus Board of Education, Tanker versus Des Moines? Well, Brown versus Board of Education extended that 14th Amendment's equal protection under the law. Which case was known as separate but equal? Well, it wasn't very equal. This was not a good one. It was Plessy versus Ferguson. Remember, Plessy is the separate but equal case. Okay, Gideon versus Wainwright, Miranda versus Arizona. These expanded the rights for people accused of a crime. Okay, when the Supreme Court ruled in Brown versus Board of Education that separate but equal has no place in schools, they were, again, going back to that equal protection of the law as guaranteed by the 14th Amendment. Okay, which headline shows us judicial review? Congress passes a civil rights law. There it is. New York State's plan ruled unconstitutional. Judicial review declaring something unconstitutional. Why has Gideon versus Wainwright and Miranda versus Arizona been criticized? Well, some people don't really like the fact that this is giving more rights to people accused of crimes. Okay, and that is it. I know it's been a long one. Up next again, we've got the rule of law and types of laws, so be sure to subscribe. Just a reminder, teachers, that this PowerPoint, lesson plans, activities, worksheets, etc. are all available at Teachers Pay Teachers. Just search for Mr. Raymond Civics EOC Academy. Thanks for watching, guys.